The People versus Carlos Lorenzo Durham. Case number 2259974. Count one. Only count one. Police officer resisting and obstructing. This is a habitual offender court offense notice. And also case number 2258771. People versus Carlos Durham. Mr. Durham is charged on this case with count one, weapons, firearms, possession by a felon. Count two, weapons, felony firearm. Count three, weapons, ammunition, possession by a felon. Count four, weapons, felony firearm. Count five, carrying concealed. Count six, police officer assaulting, resisting, and obstructing. And this is a habitual offender court.
Alexander Kirker on behalf of the people, P86282.
Good morning, Your Honor. Delisha Taylor Coleman, P56278 on behalf of Mr. Durham on both matters for bond redetermination.
And Mr. Durham, can you state your full name for the record, please?
Today, we're back inside the 36th District Court, where Carlos Durham is facing a mountain of serious felony charges. Weapons offenses, felon in possession, resisting and obstructing, habitual offender status. Before a single argument is even made, the weight of the situation is obvious. This isn't a minor misunderstanding. This is a defendant standing in front of the court with everything on the line.
As before it, I believe Mr. Durham has a capias with this court, or maybe it was with Judge Elise Bryant. At this point, we'd ask for any capiases to be recalled. That he is a resident of Detroit. He has significant family contacts. I'm looking up his investigation report. I'm looking up the sheet from misdemeanor felony defenders on his behalf. Long story short, we're asking for a personal bond with tether, and that we would reappear. Address the capias of December 14th, Mr. Durham.
I'm sorry, what did you ask him? I didn't hear the first part of your question.
Address the capias of December 14th of 2022.
Yes, go right ahead.
Mr. Durham, were you aware of that court date?
Yes, and kind of no. They bombarded me with a bunch of court dates, and I kind of might have forgot it because there's so many I got to go to.
Okay,
they sent me about 40 different cards with court dates on them.
You essentially made up your court date.
I think so. I got court dates all the way to February.
As the clerk reads through the counts one by one, the list keeps growing. Multiple firearm-related charges, ammunition possession, carrying concealed, and assaulting or resisting a police officer. On top of that, the prosecution identifies him as a fourth habitual offender, meaning prior convictions are already part of the equation. The stakes couldn't be higher. Bond reconsideration is on the table, but with this record and these allegations, the court has serious concerns about risk and compliance.
Okay. Your Honor, we believe that this was just a mistake, a one-time mistake. As the court can see in the register of action, Mr. Durham had appeared at previous court dates, but as he stated, because of the number of court dates, this one fell through the cracks, but he would reappear at all future court dates. These are non-assaultive crimes. We're asking for a personal bond, reinstate the bond with tether. Would the court consider any reduction at all? I don't know if Mr. Durham can post any amount of money. Was there a change in your bond before Judge Bryant, Mr. Durham?
So the what? I didn't hear you.
Was there a change in your bond before Judge Bryant?
Yeah, it was a $10 bond. That's all it is. They said it's a $10 bond. I'm here to get this bond reduced so I can get out of jail.
On both cases, I am going to wait until we get to the probable cause conference on the 25th with the DSU report to determine whether or not I'm inclined to reduce the charge. I need him to show the court for something because we're back at the probable cause conference. I want you to listen up very carefully. Your next court date is January 25th. That is a Wednesday at 8:30 a.m. Can you hear me?
Yes, ma'am.
Okay, so you'll be zooming in from the county jail, and you'll have an attorney present to discuss with you any matters before we go on the record, okay? So show up for that, or you have to show up for that. Then your attorney then can possibly discuss something once we have a DSU report, okay? Attorney Taylor Coleman, anything from defense?
That's it.
When questioned about a previous missed appearance, Carlos admits he kind of forgot due to having multiple court dates scheduled. The judge presses him directly. Will he appear at all future hearings? His attorney argues it was a simple mistake, one that fell through the cracks. But from the bench, the concern is clear. Courts rely on consistency and accountability. With numerous pending matters and prior absences, the judge signals hesitation about modifying bond conditions. Trust must be earned, especially in serious felony cases.
My name?
Yes, your name.
My name is Carlos Lorenzo, and I'm here to represent the person you got on that paper, which is an all capital name, all capital letters. That's a corporation, and I'm not claiming to be him, but I'm here to represent him. All capital name is all corporation. I'm not a corporation. I'm not dead. I'm not a fictitious entity. So I'm not claiming to be whoever name you have on that paper, which is probably in all capital letters. That's not my name. It's two names in this court that sound exactly alike, and only one of them is mine. What name is on that paper y'all have over there? Is it in all capital letters? That's not my name, but it's my property. It's my trademark trade name, and I own it. And I need to know if anybody has permission to use it from me. So do we have that understood? I am not a U.S. citizen. I'm not him. I'm claiming not to be him.
I just wanted to know who you were. Thank you. I had to check there. Attorney Simon, thank you. Richard, you want to speak to your client in private before we go on the record? Because he's still talking.
Sorry, Judge. Can you repeat that, please?
Do you want to speak to your client in private for a moment? Because he hasn't stopped talking for the last 10 minutes. He's still talking. He doesn't know he's on mute, but he's been talking.
I just saw him Monday at the jail, but okay.
Okay, because I don't think we could have his hearing unless he understands we all can't talk at the same time.
All right.
2 days later, the tone changes dramatically. Carlos no longer simply identifies himself by name. Instead, he launches into a familiar sovereign-style argument, claiming the name written in capital letters represents a corporation, not him as a living man. He states he is not a U.S. citizen and insists the court lacks authority over him. The judge remains calm, attempting to clarify basic identifying information, but the exchange quickly becomes circular. The legal system operates on established definitions, and the court is not obligated to entertain alternative interpretations of identity.
So Durham, case 2259974. Mr. Durham is charged with 1 count of police officer assaulting, resisting, and obstructing. This is a habitual offender fourth offense notice. Also, case 2258771, the People versus Carlos Lorenzo Durham. Mr. Durham is charged with count 1, weapons, firearms, possession by a felon. Count 2, weapons, stony firearm. Count 3, weapons, ammunition, possession by a felon. Count 4, weapons, felony firearm. Count 5, carrying concealed. Count 6, police officer assaulting, resisting, and obstructing. This is a habitual offender fourth offense notice. Today's the day set for a probable cause conference. Appearances.
Alexander Kirker on behalf of the people, P8628.
Good morning, Your Honor. Jonathan Simon, P35596 for Mr. to both matters.
And Mr. Durham, can you state your name, please?
Objection. I'm not a mister. I just told you that it's two names that sound exactly alike and only one of them is mine. My name's never been spelled in all capital letters, so that is not my name. Whatever name you have on that paper is a corporation and it does not exist. That's not who I am. I'm not.
What is your name?
I'm here to
sir?
represent him.
What is your name?
My name is Carlos.
As proceedings continue, the judge pauses and offers defense counsel a private breakout session with his client. It's a telling moment. When defendants speak over the court or refuse to answer direct questions, it can complicate their own defense. The prosecutor and defense attorneys are prepared to address the charges, but cooperation is essential. Repeated objections over name formatting and jurisdiction don't halt proceedings. The court proceeds based on statutory law and procedure, not personal belief systems.
An entity on that piece of paper, and I'm not.
What is your last name?
What is your name, ma'am? Can I have your name and your oath of office, please? Did you take an oath to uphold the Constitution, ma'am? Or did you take an oath to violate my constitutional rights in conspiracy with the prosecutor and the Detroit police?
Attorney Simon, what I'm getting here is that Mr. Durham is not present.
Objection, I'm not a Mr.
I can enter a capias because that's not Mr. Durham. Or
Judge, maybe we could have a competency referral.
Eventually, the judge shifts focus to a competency evaluation, a formal process used to determine whether a defendant understands the nature of the charges and can assist in their defense. This is not a punishment. It's a safeguard within the justice system. With multiple serious charges pending and probable cause conferences ahead, the case is far from over.